Everyone, welcome to SIIA TechChats. Joining me this week is Chris Wiech, partner at Baker Hostetler. Baker is one of the nation's largest law firms, and Chris is an expert on IP and technology transactions. So we are grateful to have him here to discuss common issues in disputes over software implementation. Chris, thank you so much for joining us.
Thank you. Thank you for having me.
Well, let's jump right in. Realities of litigation are often not considered at the front end when negotiating software implementations. So what are our risks as vendors, providers, or even as customers?
Software implementation disputes tend to follow a recurring fact pattern, depending whether you're the vendor or you're the customer. Usually from the customer standpoint, the allegations that you see when disputes arise are that it costs more than it should have, it took longer than it should have, it doesn't work the way I thought it would, you told me it would do one thing and yet it does another. Now, if you're the vendor, though, the position always tends to be that, well, I did what you asked me to do, I followed your instructions, your line of business people, told me this is what you want the software to do. Or the client changed its mind and we changed the project based on that, or they just didn't follow our advice. So those are typically the sort of he said, she said, he said type of fact patterns that arise and lead to litigation, and the damages though can range from very small, a few months of fees to I have a case right now where they're seeking a customer seeking close to $1 billion when it's all told for the cost to, under their allegations, the cost to develop the project, the overages, and then the cost to get the project fully stabilized, and a lot of other incidental damages along the way. So it just shows you that no matter the size, the facts can be somewhat common, but the end results can greatly differ.
So what are common claims and theories of liability asserted against vendors when problems actually arise?
What you normally see when plaintiffs plead their cases, ironically, they don't typically lead with the contract claims because they want to get out from under the contract. So they will allege a variety of tort claims, most common fraudulent inducement, that the vendor misrepresented what they were going to do or what the software was going to do and fraudulently induced me into this agreement. Therefore, I'm not subject to it. You also see negligent misrepresentation claims. Sometimes you see breaches of fiduciary duty, unjust enrichment. Depending on the customer, you might see some consumer protection statutes pled. And then you also have your breach of contract, breach of warranty, and then depending on what happened, what the mishap was, if it was in relation to data, you might see some data privacy-related claims as well.
So then what contractual protections does the vendor have?
Most vendors and most software development contracts will always have limitations of liability, will have exculpatory clauses which aim to do principally two things. You want to have the customer agree to waive certain types of damages, usually consequential damages, lost profits, special damages, indirect damages, any sort of unforeseen damage not arising from the four corners of the agreement. You also see in limitations of liability a cap on damages. So notwithstanding the waiver of certain types of damages, that if the vendor is at all liable under the contract, their liability will be capped at a certain amount. Those are the two. That's the main way to try to preserve some protect the vendor. You also see arbitration clauses, choice of law provisions, and then limitations of warranties, disclaimers of warranties, things like that.
Now, with the courts, what will they consider in deciding whether to enforce contractual limitations?
courts are going to look at exculpatory clauses very closely. It is, by its nature, a waiver of a substantive right. So in most jurisdictions, to be enforceable, exculpatory clauses have to be what is known as prominent or conspicuous. The provision itself has to jump out of the page. And so a lot of vendor agreements, you'll see limitations of liability in all caps, in bold, that the clause itself will be noted as this is a limitation of liability, just so it meets that prominence requirement. Courts will also look at the sort of relative bargaining powers of the parties. Was this a contract of adhesion? Or was it more of an arm's length transaction? Was this clause negotiated, or was it a take it or leave it? Now there's some, further discussion getting on that, and also does the damages limitation of liability, particularly the cap, have some relation to the contract price? And a good example, would be if you had a $50 million implementation project and you had a cap of $10,000. That a court would look at that and say that has no relation to the contract price. That's not a reasonable allegation of risk, and that may be, under the circumstances, unenforceable. So those are some of the things the courts will look at.
So are there any other types of claims and issues that we can expect?
Yes. In addition to contract claims, as I mentioned earlier, plaintiffs will plead tort claims in an effort to get out from under that contract, to not be limited by the exculpatory clauses in the contract, and rather rely on the common law and the jurisdiction whose laws apply. And a lot of times you'll see a fraudulent inducement claim, as I previously mentioned. But what is interesting about that is, depending on the state whose laws are going to apply to that fraudulent inducement claim, you may have some difficulty as a plaintiff asserting it. Now, first of all, you've got to show a misrepresentation. And, a lot of times in RFPs, vendors will say, we have state-of-the-art software. We're uniquely situated to provide this offering. We have industry-leading best practices. Now, plaintiffs who say, those were misrepresentations because, as it turns out, you weren't very good at your job. Well, is that a misrepresentation, or is that really what courts consider puffery? Sort of advertising, marketing, and not really a factual misstatement. Also, in some states, like I practice in Georgia, to assert a fraudulent inducement claim, at some point, upon discovering the fraud, you have to rescind the contract. You have to restore the benefits to the vendor and then elect to sue for damages arising from the fraud. That's not always easy to do. If it's simply, here's your junky software back, if you think about it in a practical standpoint, that's not something that in big projects you can really do. Also, you'll see some fiduciary duty type claims, but that's problematic because software vendor's not a fiduciary. If you have claims that are fraud arising independent from the contract, then you have other issues with where was the duty. There's no confidential relationship between the customer and the software vendor. So those are some problems with the tort claims. But probably the biggest problem that any plaintiff's going to have in asserting a tort claim is the economic loss rule. In most states, follow the economic loss rule. Even when there's not a contract, sometimes it says you can't recover in tort for purely economic loss that arise out of a commercial agreement or contractual agreement. And there's a couple of exceptions that typically don't apply.
Wow. Chris, thank you so much for your time and insights today. For more information on Baker Hostetler and their services, you can visit their website and join us next week for another SIA Tech Chat.